They did it again. They did it again. Once is a mistake, twice is a habit. The end of today in the Clancy trial was what in legal settings is known as a toothbrush moment. A part where an attorney's actions are so egregious that sometimes the judge asks, "Did you bring your toothbrush?" Meaning, I'm going to hold you in contempt and I'm going to make you think of your actions overnight in the courtroom basement. Now, did it go that far? Well, I don't think so, but let's go through it. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
Yeah, I'm Nick, Santa Claus, and I am here to bring you legal analysis and snark. So, today in the Clancy trial ended with a bang. Now, for you who follow it, or maybe if you don't follow it, but you do know there has been a mortal sin moment in this trial, where the judge admonished the prosecution for bringing in religion. Now, according to statute, you cannot do this. You cannot bring in dogma. You cannot bring in religious teachings in a case like this. You just can't. So the prosecution did it once earlier in the trial. They were admonished by the court, and the jury got an instruction. And today, what should have been the last day of evidence, they did it again. Now, let's watch how it happened.
Children would have been without her, and she thought that they would suffer. And she'd been having these thoughts both about herself and about her children over a several-month period. And the other thing that I will say is that she was in pain. She was suffering. She was doing a little bit better than she had been before she went into McLean. But she was still in pain. She was suffering. I think she was even desperate. And that is something that is often characterized as people who try to take their own life. They're in pain, they're suffering, and they're trying to put a stop to it. And I think when she decided at some point that she was going to put a stop to it, then she had to answer the question of what to do about the kids. And she didn't want to leave them, and she was convinced that they would suffer without her.
Now, generally, this is not bad testimony from this particular witness. It's reasonably good for the state, but it also leaves openings for the defense. Now listen.
And further evidence that you saw for the suicide combined with altruistic filicide?
There was. One of the things that she said when asked about what happened is that in the course of strangling each child, she said, "Go to God, baby, go to God." And that was part of her expectation, that she and the children would be together in heaven with God. She was raised as a Catholic, and this, considerations, that's not necessarily what happens. But when I asked her about that, when I said, isn't suicide a mortal sin?
Yeah, can I see counsel over here?
Yeah. This here, in my opinion, now, this, every witness for the state should have, after the first time, every witness should have been instructed by the prosecution, do not bring this up. I believe that not only did the prosecution knew this was his reasoning, in my opinion, they elicit this particular reasoning, but via their questioning. Not out loud, but enough to direct the witness to this. Now, look at what happens just before this moment. Look, back up here. Look at the judge.
With God. She was raised as a Catholic, and
look at the judge.
As I understand, Catholic consider.
He is looking first over at the defense. Now he's looking over at the witness. This is the judge. Oh, hell no. You are not going there. Please do not go there.
That's not necessarily what happens, but when I asked her about that, when I said, isn't suicide a mortal sin?
Yeah, can I see counsel over here?
Yeah. Everybody in that courtroom knew where this was headed. The judge saw it coming. The defense, now the defense, until he says it, they can't object. A preemptive objection is improper most of the time. But everybody knew it. And here's why I believe the prosecution elicited it. They saw where he was going, and they did nothing about it. Absolutely nothing about it. So there was a sidebar. And then this.
All right, so I'm going to ask you to go back to the jury room, and then we'll bring you back in a couple of minutes. All right?
Court, all rise.
Yeah. Jury. Now, the jury isn't stupid. The jury isn't stupid. They know the state has already been admonished about this, and then it is brought up again. The jury isn't stupid. Now, for me, this is bordering on the state knowing they have a bad case. So they are eliciting these answers to get a mistrial. Because a mistrial means she stays in jail. And they get a new shot. Because now they know the defense tactics. Now they know the type of cross-examination Reddington will do to their witnesses. Now they might exchange expert witnesses, because Dr. Mack, in my opinion, should never handle any patients. I mean, Dr. Mack has caused reversals of convictions because he opined about things he knew jack shit about on more than one occasion, which is horrifying. This is a horrifying thought, that the prosecution, so desperate for a win, that they actively sink their own case, hoping to get a mistrial. I am bordering on that is what I'm doing. So, okay, but let's listen to the reasoning here from Mr. Reddington. Let's see if it's now or. Okay, let's skip ahead till after the.
Purpose of the record, we return back to the trial of Commonwealth versus Lindsay Clancy. All parties are present, excluding the jury.
All right. After the following sidebar conference, I think the defendant made a motion. I'm going to allow argument in regards to the motion. I'll hear first from the defendant, and then I will hear from the Commonwealth. Mr. Reddington.
Thank you, Judge. Your Honor, this has been obviously a long trial and a lot of work on the part of everybody involved, from the court to the staff to the prosecutors to myself, and needless to say, the strain on Lindsay Clancy. I have to move for a mistrial reluctantly. The reason is that this is intentional misconduct on the part of the prosecution. You know that this whole idea of injecting Roman Catholic faith, the concept of mortal sin, into this trial occurred, I don't even remember now, about a week ago. And I objected, but before I could get the objection out, Your Honor had us at the sidebar at the same time, and very forcefully, in my opinion, indicated to the jurors that they should not consider that to any degree. At the time, I put on record the fact that I did not feel that I felt that the court's instructions were sufficient. They were forceful. They were right on point. And we moved forward without a motion for a mistrial. I made a tactical decision.
Yep. The tactical decision here is Reddington. Of course, he can't do a decision without talking to Lindsay. The state is doing bad. So even with this, and especially with how the judge admonished and corrected the jury the first time, that was tactically a good sign for the defense. Which also means tactically he abandoned that as an appellate issue by accepting that, which is really, really hard, because generally you do not abandon appellate issues like this. This forced his hand. He could do that tactical decision once, but repeatedly making that decision to abandon an appellate issue? No, the state forced his hand, I believe. Because the state must know they are doing extremely poorly. I am on the border of having the opinion that they are actively sinking their own case in order to do it all again. This is what I described at the beginning, a toothbrush moment. You hear it sometimes with attorneys, that some always brings a toothbrush to court, just in case they are held in contempt over something, either righteously or wrongly. Have a toothbrush, because if push comes to shove, you might have to spend the night in jail or in the courthouse basement cell to reflect over your decisions. This here is a toothbrush moment for the state. It is my opinion that the prosecutor, as admonishment, not in front of the TV cameras, not in front of the jury, but yeah, you're not going home tonight. You are going to spend the night in the courthouse basement, and we will see you back here tomorrow morning. This is bordering on a bar complaint, even. I wouldn't be surprised if a bar complaint will be filed after this trial, because the trial isn't over yet. We still have closing arguments and stuff like that. Yeah, so spoiler, it didn't become a mistrial. But let's listen to what they have to say first.
Unfortunately, at this point, it's a concern I have because this is just over the top. It's the same thing again, talking about religion, talking about heaven, talking about killing people and the impact or the effect that it would have on Lindsay as well as her children. The fact that this is not the first time that it occurred during the trial, and the prosecution has previously brought up the concept of mortal sin, based on your ruling in the past, in conjunction with the fact that they brought it up again, I believe it was intentional misconduct, and I feel that the court should grant the motion for mistrial.
All right, thank you. Kamal?
Thank you, Your Honor. The question I asked the witness did not ask for any testimony about religion, about Catholicism, about mortal sins, or anything like that. And the slide is still up on the screen. There's nothing on the slide about Catholicism, about mortal sins, about any of that. The witness was explaining his reasoning. I don't think it was intentional on part of the witness either. If we look,
You who have been on my channel for some time, you know I have a built-in BS meter. This BS meter is tingling, like very, very much. She has hired this expert witness. She has talked to this expert witness. She knows his reasoning. And in my opinion, even though it isn't spelled out loud, the indication, the indicia is still there. She knew he was going there, and she did nothing to stop him. She just gave herself this out. Well, it doesn't say so explicitly, and I don't think who was going. I don't think it was. I think it was a mistake. I don't buy it. I think it's BS. Let's continue.
at his interview of Ms. Clancy, one of the things that this witness has to do is determine whether the defendant knew the wrongfulness of her conduct. And that can be either that it was criminally wrong or morally wrong. And he explored that with her in the interview and asked her about whether she knew it was legally wrong. And she said she had no concept of legal consequences. And then he went on to ask her about moral wrongfulness and about her religion and whether she knew it was morally wrong. And she did say that she had knowledge that suicide was considered sinful. So.
And there she says it out loud. She knew this was in the interview. She knew. She knew where it was headed and did nothing to stop it. That is, in my opinion, based on the prior ruling, that is contempt of court. That is, for me at least, my opinion. If you disagree with me, tell me in the comments. But for me, this is clearly in the area of contempt of court. As an officer of the court, goes to both sides, you have an obligation to the court to conduct yourself. She didn't. Twice. The state brought in something that is taught in law school. The precedent, the statute of this is ancient. You can't go into this area. You can't. She still did it. This here is a toothbrush moment.
I believe that's where the witness was going in trying to explain his reasoning. I don't think he was intentionally trying to inflame the jury or cause an issue in this case. I know I certainly wasn't, because I didn't ask a question about her religion or a question that would invoke that kind of response. I asked him to explain what was on the slides, and that's not on the slides. So there was no intentional conduct by the Commonwealth. That was not where I intended to go with this questioning.
Bullshit.
And I don't think that the witness intended to do any harm either. He was just explaining his rationale. So I would ask that the jury be instructed to disregard the answer, and I can speak to the witness and tell him not to talk about that reasoning.
Something you should have done, because you had knowledge that is where the interview went. You had active knowledge through a court decision, through court. Don't go there. Still did.
Or behind his thoughts, that he can testify about his conclusions, but to leave that portion of his reasoning out of his testimony.
Well, here's a concern I have, is what the witness did say in regards to go to God, baby, go to God. That was statements that had been made in evidence already. And then he indicated that was part of her expectation, that she and the children would be together in heaven with God. All right. Now we're getting a little closer to problematic area. Then he testified she was raised as a Catholic. And as I understand Catholic considerations, that's not necessarily what happens. How is any of that proper at this point? But it was not, I'm not going to declare a mistrial at this time.
At this time. Again, if you've been here before, you know my focus is what's the wording here. I am a strong advocate in listen to the words they are actually saying. The judge adding at this time means it's still a consideration. The ruling is not definite when he adds at this time. That is a warning for the prosecution. Don't go once a mistake, or can be explained as a mistake. Twice is a habit. I don't know if this judge is 3 strikes you're out type of judge, but he at least indicates that he is.
What I am going to do is I'm going to bring the jury in. I'm going to tell them to disregard it. I'm going to tell them that's an inappropriate area of inquiry, and that this witness's understanding of Catholic dogma or Catholic teaching is irrelevant. There's no evidence of his background or training or having been to the seminary or any of that. And so I think, and that's where he injected that. And so I am giving that, but the Commonwealth, I'm going to strongly, and perhaps the strongest language, talk to him and let him know that he can't go into that. And then my thought is, I'm going to bring the jury back in. I'm going to give them that instruction, and I'm going to send them home. I don't want them leaving here today with the last thing they heard was a discussion about this witness's understanding of the Catholic teaching. That's not the last thing they're going to hear. And so my thought is that as best I can is to address that and minimize the damage or prejudice, because I do presume that this jury will be able to follow those instructions. And so that would be my thought. We'll come back. That will give the Commonwealth plenty of time to talk to this witness, to let him know the areas that he should and should not go into. And then we can come back tomorrow and we can resume his direct examination and cross-examination. All right, so that'll be my thought. We'll bring the jury in. I'll give them that instruction, and then we will recess until tomorrow. Okay?
Your Honor, and just for the record, could I note an objection?
Sure, absolutely. All right, so we ready for the jury?
Yeah. No mistrial. The instruction, it was very, very clear, concise. This judge is very good at instructing the jury. But yeah, in my opinion, the prosecution should have been made the thing that crawled in the background was a moth and nothing else, by the way. Folks, I live on a farm. There's creepy crawlers. Sorry. Where was it? Yeah. In my opinion, the prosecution should stay the night in the basement of the courthouse thinking about their decisions to make better decisions for the remainder of the trial. This is the last witness, to my understanding. Then follows your instructions, closing arguments, and then it's handed over to the jury. This might take a while. This decision from the jury might take a while. Now, folks, her acts, Lindsay Clancy, are absolutely horrifying. Everybody agrees on that. There's no question about it. The question before the jury is, did she have a psychosis, a psychotic break while doing it? And if they declare her innocent by reason of insanity, that doesn't mean she will walk. That means she will be locked up in a different type of prison. I will give you an example. Remember the mother who drowned her 5 kids? She was sent to a mental facility. This was back in 2001. 24 years later, she's still there. She will, by the accounts of the few attempts that has been made, she will stay there for the remainder of her days. Lindsay Clancy, for the past 3 years, has been on a 24/7 self-ending watch. She's not going anywhere. She's not going anywhere. It's either prison or a mental asylum. Oh, and by the way, no, Patrick had nothing to do with it. Stop with that nonsense. All right, that is what I had for you. Thank you for listening in. Comment below, leave likes, subscribes, you know all the drill. And if you want me to cover more aspects of this trial, let me know. Thank you. Have a good one, and I will see you all in the next stream or video. Bye-bye.
Santa Claus, riding in with the winter law.